Good morning, friends. How are you? Myself, Dhirendra Kumar. We are going to discuss today a very important topic of Criminal Procedure Code, and the name of the topic is bail. 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 Bail, in its simplest connotation, means conditional release of a person who is in custody either of the police or of the court. So, bail connotes conditional release of a person who has been detained in custody Bail is a very popular word. It may be a notorious word as well, a word of very commonplace currency. Depending on the situation, how you look at it, bail may be a desirable situation, it may be an undesirable situation as well. If the person who is being talked about is a notorious criminal, then certainly society will have a general feeling that this person should not be released on bail. But if a person is not of any criminal background, he is a civilized person, he is a well-behaved person, for some unintentional default on his part, he has landed up in some trouble, then the general feeling in the society is that this person should be given the concession of the law in terms of bail. He should be released pending investigation and trial as well. So, bail is a situation of deliverance. It is a situation of conditional release. Now, in order for bail to apply or in order for bail to come about, first an arrest has to happen. Arrest has to happen, then only will the question of bail arise. And when arrest does take place, actually, a person commits crime or a group of persons commit crime, police gets the information as to the commission of the crime, as to the happening of the crime. Police responds to the situation, police responds to the state, police responds to the spot and picks up investigation into the matter. Right. Picks up investigation into the matter in order to collect evidence, and the purpose of collection of evidence is what? To haul the accused before the court in order to get him punished by the process of law, so that a deterrent is created in society that if you commit crime, you will have a price to pay. You will have to undergo imprisonment, or maybe he will have to face a death sentence as well. So, a person is arrested because he is suspected to be involved in a crime, in the commission of a crime. Now, crimes, offences are of different categories depending upon the situation. Some crimes are very serious ones, some others are not so serious ones. So, it is not required in all cases, or it is not required in all criminal cases that a person has to be necessarily arrested. It depends. Whether a person has to be arrested or not will depend on what kind of offense he is actually involved in. Suppose a person is accused of slapping, beating generally another person, then certainly this is not one such case where the person will be put into arrest. But if a person has caused grievous hurt to another person, then certainly arrest becomes necessary. So, it is always a very important question for the police, for the prosecution to decide that whether the reported offense is one such offense where arrest has to take place or not. And how does the police decide about it? The police has to see the provisions of the Criminal Procedure Code. Criminal Procedure Code CRPC, Criminal Procedure Code, is a piece of law which was enacted by the Indian Parliament in 1973. It constitutes an improvement or an amendment over the previous procedural law of the British time, which was in the form of Criminal Procedure Code 1898. Due to several reasons, after independence, amendments were required, and accordingly the Indian Parliament rose to the occasion and brought about certain amendments, enacted certain amendments, and the final form of the procedural law as it stands now is in the form of Criminal Procedure Code 1973. So, this Criminal Procedure Code, the provisions of this Criminal Procedure Code provides for the several conditions of bail. It also provides for several rules as to how the police has to go about investigating a particular case, how the police has to go about effecting an arrest of a person. So, the procedural law CRPC 1973 contains Schedule First. Schedule First of the Criminal Procedure Code is very important in order for the police to be able to decide whether a criminal case, whether a case is a cognizable one or not. Because the law says, this law says that arrest will necessarily, mandatorily happen only in cognizable cases, not in non-cognizable cases. So, first we will have to understand what are cognizable cases or cognizable offences and what are non-cognizable offences. Non-cognizable offences. Simply put, cognizable offences are very serious kind of offences like murder, rape, dacoity, etc. Whereas non-cognizable offences are not so serious in nature. For example, slapping, beating harmlessly is a non-cognizable offense. So, cognizable offenses being serious ones require serious intervention on the part of the police. Here in cognizable cases, the police is having a bounden duty to arrest the person who is suspected to be involved in the commission of the crime. And if you open up the first schedule of the CRPC, you will find a documentation, you will find an scheduling or listing of offences. On the one hand, you will find the numerical mention of all the offences contained in the Indian Penal Code, alongside the description as to whether this one is a cognizable or non-cognizable offence is given, and also in the first schedule itself has been indicated whether this case under investigation has to be tried by a judicial magistrate or a sessions judge. So, schedule first is of very important concern so far as the police gets to decide whether police has to arrest a person or not. So, suppose the Criminal Procedure Code says, or in fact it says that section 302 of the IPC, which provides for punishment for murder, is a cognizable offence. It means a person who is suspected to be involved in committing murder will have to be necessarily arrested, right? But if a person who is suspected or reported to be involved only in an act of slapping, he may not necessarily be arrested because the offence falls under the category of section 323 IPC, and the Criminal Procedure Code, its first schedule indicates that section 323 IPC which provides for punishment for hurt. Slapping is an example of hurt, causing hurt. So, here section 323 being a non-cognizable offence, the police is not having a bounden or mandatory duty to arrest the person who has slapped another person. So, schedule first tells it all. Now, a person is involved in a cognizable offence, he will be arrested definitely, right? And once he is arrested, he is required to be produced before the judicial magistrate. Mind you, if a person is arrested in one such offence which is though cognizable, but at the same time it has been indicated or it has been mentioned as a bailable offence as well. So, if the crime is a cognizable one, but it is a bailable one as well, then in that case that person will be of course arrested, he will be taken to the police station, but from the police station itself he will be released after having completed some formalities. So, schedule first also mentions that whether the offence is a bailable offence or is it a non-bailable offence. Is it a non-bailable offence? For example, being part of an unlawful assembly is an offence. Farmers demonstration is going on, and the purpose of the avowed objective of the demonstration is to oppose the law which has been recently made by Parliament. Now, that may be declared an unlawful assembly by the executive magistrate or the police officer present at this spot. And if you are a member of that unlawful assembly, then section 143 says that you are involved in the commission of a crime. It is your ongoing involvement that is cognizable there. So, if you are a part of the demonstration and if that assembly of people has been declared an unlawful assembly, then you will be said to have, you will be accused to have committed an offence. And because section 143 of the IPC is a cognizable offence, therefore, police has every right to take you into custody, but because section 143 is also a bailable offence, so says schedule first of the CRPC. Therefore, police has a duty to release you from the police station itself, and police will require you to fill up a bond before it releases you. So, you will be released on bail from the police station itself because the offence is a bailable one, and the police may release you either on bail or on your personal recognizance or personal bond. We will discuss how these two things are different, bail and personal recognizance, right? But see, as I talked about section 143 IPC, section 143 IPC, being part of an unlawful assembly, is a punishable offence. It is a cognizable offence. Schedule first of the CRPC says section 143 IPC is a cognizable offence, but at the same time the first schedule also says that it is a bailable offence. Therefore, if you are a part of unlawful assembly, for example, farmers protest, etc., then you may be taken into custody, but because it is a bailable offence, therefore, you will be released by the police itself. And before the release, the police may require you to fill up a bond, either in the form of bail or personal bond, right? But suppose you have been arrested because we were part of a demonstration and that demonstration was declared as an unlawful assembly. You were arrested and you were being taken to the police station, and while on the way to there, you thrust one of the police official. Now, thrashing or beating or causing hurt to a public servant on duty is a cognizable offence according to section 332 of the IPC. If you cause hurt to a person who is on duty, a public servant who is on duty, then section 322 IPC will attract, and according to the first schedule of the CRPC, this one is a cognizable offence, and at the same time it has been indicated to be a non-bailable offence as well, which means if you thrash the police official, you may not be released from the police station itself, because section 332 IPC says that whoever causes hurt to a public servant on duty shall be punished with an imprisonment for a term of 3 years or with fine or with both. So, because it is a non-bailable offence, section 332, here the person who has been arrested shall not be released by the police. In a cognizable and non-bailable case, the arrested person, the accused who is in custody, has to be produced before the judicial magistrate. As you are aware, it is a constitutional provision as well that a person who has been arrested in a cognizable offence, in a non-bailable offence, has to be produced before the nearest judicial magistrate, and this takes us to Article 22 of the Indian Constitution. Article 22 of the Indian Constitution is of great importance here. Article 22 is part of the fundamental right that we as the citizens of the country enjoy, and Article 22 says that a person who has been arrested shall be informed of the grounds of his arrest as soon as possible, and he shall be given the right to consult and be defended by a lawyer of his choice, and also he shall be produced before the nearest judicial magistrate within 24 hours of his arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate. So, in a cognizable case, in a non-bailable case, the release is not going to happen from the police station. The release or the bail, if at all it has to happen, if it has to apply, will apply only at the court. In Miranda versus Arizona, the American Supreme Court has said that the moment a person is arrested, he has to be informed of his rights. That, sir, you are being arrested under so and so accusation. You have a right to remain silent or speak. If you speak anything, that may be used against you in a court of law. You have a right to consult and be defended by a lawyer of your choice. If you can't afford one, we will make you available. We will make you one available at the government's expense. Similar provisions are there in Article 22 of the Constitution. A person is required to be produced before the judicial magistrate within 24 hours of his arrest. Within 24 hours. Within 24 hours of the arrest. Judicial magistrate. Area magistrate, Ilaka magistrate, these are the words he is also characterized by. Judicial magistrate comes into the picture. So, a person who has beaten up a public servant on duty will be charged with the section 332 of the IPC. He will not be released from the police station. The police will produce that accused, that person, before the judicial magistrate. And the judicial magistrate before whom the accused person has been produced has to exercise certain functions according to section 167 CRPC. In fact, section 167 CRPC, to my mind, represents the magna carta of the judicial magistrate. A whole lot of power has been given to judicial magistrate here. Now, judicial magistrate will hear arguments from both sides. The accused will also say his piece in order to defend himself. On the other hand, the investigating officer IO or the assistant public prosecutor APP generally will make out a case against the release of the accused. If the judicial magistrate becomes satisfied that the case is not of a very serious nature, the accused is not of a person of criminal antecedent, he is a rather civilized person, a responsible member of the society, and there is hardly any risk of him fleeing away from the course of justice, then the judicial magistrate may choose to release him on bail. Right? The judicial magistrate may give him bail according to section 437, according to section 437 of the CRPC. Right? Judicial magistrate may choose not to give bail. He may not release the accused, given the seriousness of the crime he is accused to be involved in, given the flight risk that he may pose, right? So, he may not be released. In that case, the judicial magistrate may send him to judicial custody for a maximum period of 15 days at a time, or maybe at the time of arguments, the police or the investigating officer or the assistant public prosecutor may say that the police needs remand of the accused in order to conduct an inquiry, in order to conduct a further investigation, in order to have his help to find out the goods or the articles or the weapons concealed by him which was used in the commission of the crime. So, for the purpose of recovery of weapon, for the purpose of ensuring a proper conduct of investigation, the police may request to the judicial magistrate that please give this accused to us for some time on police remand, maybe for 1 day, 2 day, 3 day, and depending on the situation, depending on the nature of the crime, depending on the recovery to be made, the judicial magistrate may allow police remand for 1 or 2 days depending on the situation. So, while in police custody, while in police remand, the accused will be dealt with by the police. The accused may be taken out of the custody, may be taken out of the prison cell in order to find out the weapons that he may have used in the commission of the crime. Certain other disclosures might be expected of him in the process. Once the police remand is over, then the judicial magistrate again comes into the picture. Once the police remand is over, the accused is again required to be presented before the judicial magistrate. And the judicial magistrate here now either may choose to release him on bail, or the judicial magistrate may choose to keep him in custody. In that case, the judicial magistrate will send that accused into judicial custody for a maximum period of 15 days at a time, because the investigation is still going on, because the crime is very serious, because the accused is a notorious criminal, he has criminal antecedent, he is a flight risk, he may run away from the course of justice. Keeping these considerations in mind, the judicial magistrate may send the accused into judicial custody, as I told you, for a maximum period of 15 days at a time. Now, once the 15 days period comes to an end, the accused again will be produced before the judicial magistrate, and Again, the prosecution or the police side will get the opportunity to state its case. If the police or the prosecution convinces the court that the release of this person would not be suitable, would not be appropriate given the seriousness of the crime, given the kind of flight risk that he is, he should not be released. Then in that case, after getting convinced, the judicial magistrate may order him to be kept in further judicial custody, and again for a maximum period of 15 days at a time. So, every time the judicial magistrate can extend the judicial custody for a maximum period of 15 days. But section 167 CRPC says that this judicial custody cannot go beyond a period of 90 days or 60 days. 90 days or 60 days. Why 90 days and why 60 days? I explain. In serious cases like murder, dacoity, rape, etc., the judicial custody can continue for a maximum period of 90 days, and in less serious crimes like slapping, etc., like theft, etc., the maximum period for judicial custody can be that of 60 days. If within 90 days or if within 60 days, as the case may be, the police doesn't complete the investigation, if the police fails to present a charge sheet before the court, then it is a statutory duty of the judicial magistrate to release that person on bail. The investigation in a murder case, suppose in a murder case the investigation hasn't yet been completed in 90 days time, and how does one get to know whether investigation has got completed or not? Actually, the symbol or the indication of the investigation process having got completed comes into the form of a charge sheet or challan in popular term. So, if the police who is investigating the case comes up with a charge sheet within a period of 90 days in a murder case or in other serious kind of offences, then certainly the matter will go on. The accused may not be released from the custody. But suppose in a murder case, if the police fails to present the charge sheet within the maximum period of 90 days, it is a bounden duty, it is a statutory duty of the judicial magistrate to release that person on bail. And this in legal parlance is known as statutory bail. Statutory bail, because of the force, by virtue of the provisions of the statute, the prisoner is getting released. This is a statutory bail because the police failed to complete the investigation within the stipulated period of 90 days or 60 days. If suppose the police were able to present the charge sheet within the stipulated time, and if the allegation against the accused is a serious one, if the accused is a flight risk again, then the judicial magistrate may order him to keep into further custody. And at the same time, because the charge sheet has been presented to the judicial magistrate, he will commit the case for further trial, for further hearing before the sessions court. So, judicial custody can continue for a maximum period of 90 days in serious cases or for a maximum period of 60 days in not so serious cases. Right. Now, once the person against whom the investigation has got completed, he is no longer required by police to make any recovery. He is in judicial custody. While in judicial custody, he may apply for bail. Mind you, so long as the accused is on police remand, the investigation in its most serious form is going on, recovery has to be made, accused has to make disclosure. While on police remand, the provision of bail doesn't apply. Once the police remand comes to an end, the person is sent into the judicial custody. As I just told just now, the person is sent into the judicial custody, then only can he apply for bail. And once we say he can apply for bail, section 437, for section 437 of the CRPC comes into picture. Now mind you, bail is a very elaborate provision in chapter 33 of the CRPC, starting from section 436 through section 450. Bail represent a very elaborate provision into the procedural law. Section 436 is also of importance. Section 436 CRPC is about bailable offences. And section 437 is about non-bailable offences. Example of one bailable offence is section 323 IPC, hurt, for example, slapping, beating a person. And non-bailable offence, section 332 IPC, causing hurt to a public servant on duty in order to prevent or deter that public servant from performing his duty. In this case, because the offence is a bailable one, and who says so? As I told you just now, schedule 1st of the CRPC tells us that section 323 IPC is a non-cognizable offence and it is a bailable offence as well. So here, if the person has been taken into custody, then he will be released from the police station itself, either on his own bond or on bail with surety. Being a part of the unlawful assembly, section 143 IPC, if you are part of a farmers' demonstration and if that demonstration or that assembly of people has been declared unlawful assembly, then being a part of the unlawful assembly is an offence in itself. It is a cognizable offence, but it is a bailable offence. So here section 436 will apply. The person will be taken to the police station and from the police station itself he will be released by the police himself, either on him executing a personal bond or bail with surety. I will explain these terms. But before that, let us look on this aspect. While you have been arrested because you were part of an unlawful assembly, while you were being taken to the police station, you slapped one of the police personnel. And because that police personnel was on duty, therefore section 332 IPC is bound to attach to your indictment. Because causing hurt to a public servant on duty is a cognizable offence, it is a non-bailable offence as well. So here the police will keep you in custody and the police is then duty bound according to article 22 and section 57 of the CRPC to produce you before the nearest judicial magistrate, who is also called area magistrate or ilaka magistrate. Right. So this way the provision will apply. This one is a non-bailable offence. Here the judicial magistrate can only admit a person to a bail or not. Right. Now let us look at section 436 and 437 in some detail. And in order to do that, let us first analyze these two important expressions, these two important words. Bail in its simplest meaning, as I told you, is conditional release either by the police or by the court. Here the police is granting bail, here the judicial magistrate or court is granting the bail. Right. So this power is generally exercised by the police and this power via section 437 CRPC is exercised by the judicial magistrate. Now be it the police officer or be it the judicial magistrate, they require the prisoner, they require the accused to execute either a personal bond or a bail bond with surety. What is the difference between the two? Though the term bail has not been defined anywhere, either in the CRPC or for that matter any other piece of enactment in our jurisprudence of criminal law, bail hasn't been defined at all. So, we will understand this term in the sense it is understood by lawyers and judges in their regular practice, and release on bail happens. This conditional release can happen in a twofold manner: by way of executing of personal bond or personal recognizance, मुचलका, निजी मुचलका, or bail with surety. Bail with surety. Bail hasn't been defined. Bail simply means releasing a person or delivering a person to his sureties upon them giving an undertaking to the court or the police officer that the accused shall present himself before the police officer or court as and when required. Surety here says that you please release this person, have guarantee from us, we will make sure of it that the accused will present himself every time he is called upon to do so. And if the police or the court has decided to release that person on his personal recognizance, then no other person will be required to give surety, to give security or to give assurance for his orderly conduct onwards. So, here no other person is required to be brought in either at the police station or at the court. The person himself will be released. He will be required to fill out a personal bond whereby he will undertake that I so and so shall attend the police officer or the court on every day on which investigation or trial is held in respect of the case, in respect of the offence I am charged with, and in case of my committing default herein, I bind myself to forfeit to the government a particular sum of money. This is called personal bond, that I, being the accused, is making a promise, is making out a promise that I shall cooperate with investigation, I will cooperate with the process of trial, and for that purpose I will present myself either to the police officer or before the court every time I am called upon to do so. And in case I commit a failure therein, then I may be required to pay a penalty for my default. This is called personal bond or recognizance. But in bail with surety, the person himself doesn't say anything. The person who is going to get the benefit of release doesn't say anything. In his state, sureties speak. Any other person who is brought up before the police station or the court says on his behalf that, sir, please rest assured, we are the surety, I am the surety, I am the guarantee. In fact, I will make sure of it that this accused person attends the police station or attends the court on every day on which investigation or trial against him is held. If he fails to do so, I, being the surety, I, being the guarantor, undertakes to pay a certain sum of money in the form of penalty. This is called bail with surety. So, it depends upon the personal discretion of either the police officer exercising his power under section 436 CRPC, or it depends on the discretion of the judicial magistrate exercising his powers with section 437 CRPC, whether to release a person on personal recognizance or whether to release a person on bail with surety. If the person is charged with a serious offence, generally bail will be required of him, and if a person is not so charged with a serious offence, if he is not a flight risk as such, if he is a poor or indigent person also, then he may be required to execute a personal bond or personal recognizance, and he will be released from the prison simply. So, bail, the word bail in its grammatical sense is used both as a verb and as a noun. In verb form, it means to deliver a person to his sureties, and in terms of noun, bail means sureties, guarantors who have the means, who have the control over the accused. They can produce the accused before the court or before the police officer as and when required. I hope you have understood these two important expressions: release on personal bond or personal recognizance and release on bail with surety. Section 436 CRPC and section 437 CRPC both speak of these two terms. They haven't been defined, but in general practice, in the usual practice, this is the meaning, this is the explanation of these two important terms. Now, section 436, section 437 as well heads in the power of the police officer or the judicial magistrate. They cannot exercise their discretion in an arbitrary manner. They have to exercise their power in a most judicious manner, most sane manner. So, section 437 CRPC enacts certain conditions which have to be kept in mind by the judicial magistrate. Mind you, the power of granting bail with a section 437 CRPC is not to be exercised by court of session or high court. This power belongs only to the judicial magistrate, either on the wordings of the section 437 or on the basis of the law settled in this behalf. There is no doubt about this inference or conclusion that the power under section 437 CRPC is to be exercised only by a judicial magistrate, not a higher judge. And here the judicial magistrate has to keep in mind certain conditions which are laid out in section 437 itself, that if the person, if the accused is involved in a crime which entails punishment in terms of either death or life imprisonment, then no bail, no release shall be granted. If the accused is involved in having committed a case or crime which will result in or which may result in death punishment or life imprisonment being given by the court, then the judicial magistrate shall not grant that person any concession, no bail shall be given to him. This is the condition. But here the judicial magistrate does have some leverage. He does have some latitude here as well. If the person is of less than 16 years of age, or if the accused is a woman, or if he or she is a sick person, or if he or she is an infirm person, then even if the accused is charged with the offence entailing death punishment or life imprisonment, if these conditions or any of the conditions apply, then the judicial magistrate does have the power to grant him or her bail. Suppose Mr. A is involved in the commission of the murder of Mr. B. Here the offence is a cognizable one. Here the offence is a non-bailable one. Mr. A has been produced before the judicial magistrate, but the judicial magistrate will see that this murder case is one which will either result in death punishment or life imprisonment on the completion of the trial. Therefore, I am going to give no bail here. But if at the same time the judicial magistrate is made aware that Mr. A is a very infirm person, he is a sick person, or if she is a woman or a person of less than 16 years of age, then the judicial magistrate does have the discretion here, even if Mr. A is charged with an offence of having committed a crime involving death punishment, he can be released on bail by the judicial magistrate. Right. Second, if the accused person has been convicted or punished on one occasion in a case where punishment was either death or life imprisonment or any other punishment of more than 7 years of prison term, then also the accused shall not be released. Section 437 further says that if the person, though otherwise deserves bail, but if he is found to be having convicted and punished on two previous occasions in cases involving more than 3 years prison term, then also he shall not be granted bail. But here also the same condition applies. If the person is of less than 16 years of age, if he or she is a woman, if she is a woman, if he or she is a sick person, if he or she is an infirm person, then he may be released on bail by the judicial magistrate himself. Now here an important case law is worth quoting, and the case law is Prahalad Singh Bhati case, Prahalad Singh Bhati versus Delhi administration. (1980). Here the Supreme Court said that though the judicial magistrate does have the power to grant bail in those cases which are serious ones, which are exclusively to be tried by the court of session, yet in serious offences like murder, dacoity, etc., the judicial magistrate should not be exercising his power to grant bail. Rather, the judicial magistrate should direct the accused to approach the sessions court for getting bail. The Supreme Court said in so many words that vesting of jurisdiction is one thing and exercise of the same is quite another. So, though jurisdiction in terms has been vested into the judicial magistrate for grant of bail even in serious cases depending upon these conditions, yet the judicial magistrate should not be exercising the power to grant bail in serious cases. Rather, he should direct the accused to approach the sessions court in order for him to be able to get bail. Right. So, judicial magistrate's hands are very tied up in serious cases. He does not exercise the power to grant bail, even if these kinds of conditions do apply, right. So, bail in matters in cases of murder, dacoity, rape, etc., they become the exclusive domain of the sessions court, not the judicial magistrate. Now, suppose the judicial magistrate has decided to give the concession to release the person on bail, then the judicial magistrate will impose certain conditions on the accused, that see, I am releasing you on bail, but you shall not be committing any further crime of the type you are charged with as of now. You will always honor the terms and conditions of the bond and release, and you will not make any inducement, you will not make any threat, or you will not make any promise to any witness concerning the case so as to discourage or dissuade the witness from disclosing any fact either to the police or before the court. So, these are generally the conditions of bail as provided for in section 437 CRPC, right. You shall not commit similar offence like the one you are charged with hereat. You shall honor the terms and conditions of the bail, and you shall not be threatening, you shall not be making any inducement or promise to the witnesses so as to discourage them, so as to dissuade them from disclosing facts to the police or the court. These are the conditions of bail. Now, at any time, either on the application of the public prosecutor or on its own motion as well, the judicial magistrate may cancel the bail and direct the prisoner to be again taken into custody. He may not be passing a speaking order in this behalf, because the person who was on bail has committed another crime. He may be again taken into custody. His bail bond may be directed to be cancelled. The surety may be directed to be discharged. So, the condition of enlargement is that you shall behave properly while on bail. You will cooperate with the process of investigation, you will cooperate with the process of trial. These are the conditions laid out in section 437 of the CRPC. Now, with regard to the exercise of power vide section 437 CRPC, the Supreme Court in Prahlad Singh Bhati case has said in very clear terms that some reasons must be given by the judge as to why he decided to release the person on bail. A very detailed scrutiny of evidence is not required. A very detailed documentation of the merit of the case is not required, but some prima facie view of the evidence, some prima facie view as to the nature of the crime, some prima facie view as to the risk, whether the accused will cooperate with the investigation and trial or not. Some prima facie view has to be taken by the judge in his bail order. So, bail order has to be a speaking order, not a summary kind of an order without giving reason. You cannot either reject or give bail to any person. In Prahlad Singh Bhati case, this person's, the appellant herein, Prahlad Singh Bhati's daughter was murdered by his son-in-law, and in that case, the son-in-law, the accused, applied vide sections 437 CRPC, and the judicial magistrate was pleased to grant him bail, over which the father of the deceased daughter, Prahlad Singh Bhati, filed a revision petition at the High Court. And when High Court rejected the revision petition, the appellant came to the Supreme Court by way of section by way of Article 136 of the Constitution, by way of special leave petition, as you know. So, here the Supreme Court went on to say that though the judicial magistrate may exercise his power even in serious cases to give bail, but this power should not be exercised by judicial magistrate. Rather, he should direct the accused to approach the sessions court for the release, for bail, for granting of bail. And at the same time, the Supreme Court said that a detailed speaking order must be pronounced by the judicial magistrate as he chooses to release the person on bail. Now, in a recent case, namely in a rather recent case of 2004, the name of the case is Kalyan Chandra Sarkar versus Rajesh Ranjan alias Pappu Yadav, a famous politician of Bihar. The same dictum of law was repeated by the Supreme Court, and the Supreme Court, quoting with approval the law laid down in Prahlad Singh Bhati case, said that the judge must pass a speaking order for the grant of bail, must give reasons why he chose to either admit the accused to bail or to reject his bail application. Right? A very recent case, Nikesh Tarachand Shah versus Union of India, 2017, Supreme Court. Here Justice Rohinton Fali Nariman, as he then was, has done a beautiful job of analyzing the background of bail. It sheds a great deal of light on how the jurisprudence of bail has developed in India. Justice Nariman in his judgment has said that the idea of bail can be traced back to the Magna Carta of 1215 AD itself. On 15th June of the year 1215, King John of England had to sign a charter of rights of the barons, of the farmers there. Magna Carta is said to be the first written declaration of human rights, first written declaration of guaranteed rights. And section 39 of the Magna Carta says that no free person shall be seized or kept in prison without by the lawful judgment of his peers. So, in a lawful process, in a legal process only can a person be put behind bars, he can be subjected to imprisonment. And section 39 of the Magna Carta then began to be applied to pre-trial detentions as well. Either investigation is going on or trial is going on, the person who is suspected or who is accused of the offence should be released on bail. This is one of the essential aspects of the Magna Carta as it has practiced in course of, as it has developed in course of practice. Now, bail in our country derives its importance, its sustenance, its justification from Article 21 of the Constitution. Article 21 of the Constitution says that no person shall be deprived of his life, personal liberty, except according to the procedure established by law. Personal liberty is of paramount importance, and through the successive case laws, this right to life has received utmost attention and a very generous interpretation on the part of the Supreme Court. As you are aware, for the first time in the Menka Gandhi case, 1978, the Supreme Court said that right to travel abroad is part of right to life given in Article 21 of the Constitution. Article 21 of the Constitution, the way it contains the right to life, doesn't simply mean animal existence of life, cattle type existence of life. It means more than that. Amendment 9 of the American Constitution says that mere enumeration of certain rights in the Constitution shall not be construed to deny or disparage other rights that belong to the people. It means because you have mentioned certain rights into the Constitution doesn't mean that people are deprived of certain other rights which are not mentioned in the Constitution or law. Other rights are there as well. They need to be recognized. If those rights are very meaningful, very instrumental in making the life a very civilized and meaningful one, they must be given as equal an importance as that of right to life in Article 21 of the Constitution. So, the jurisprudence of Bell is well consistent in Article 21 of the Constitution. So much so that Justice V.R. Krishna Iyer, one and only Justice V.R. Krishna Iyer in Balchan versus State, very famously said, Balchan versus State, Justice V.R. Krishna Iyer said 1977 that Bell is rule and jail is exception. Bell is rule and jail is exception. Again, Justice V.R. Krishna Iyer, I often take his name with the greatest veneration because he is my favorite judge. Again, Justice V.R. Krishna Iyer in Guddikantu Narsimhalu versus Public Prosecutor in 1978 says that the question of well, the idea of well is related to liberty, justice, public safety and burden on the state treasury. If you keep a person in custody, if you detain a person in custody, if you keep a person in jail, his liberty suffers an eclipse. His liberty gets hampered. He is denied justice if you keep him without reason in jail. And if you release a person on bail, then because he is a criminal, he is a serious offender, he is a repeat offender, he may be a risk to public safety. But again, if you do not release him, his detention may cost a burden on the state exchequer. The state will have to incur the cost of his living while he is in prison. So, the idea of bail is one related to liberty, justice, public safety and burden on a state treasury. Therefore, a well-developed jurisprudence becomes an integral part to a socially sensitized judicial process. Article 21 of the Constitution has to be respected. If it is not absolutely necessary, the person shouldn't be kept in jail. He should be released on bail. Bail is rule, jail is exception. Right. So, much has been said about the desirability of bail and non-desirability of bail as well. As I was talking about the Kalyan Chand Sarkar case, Pappu Jadhav case, Kalyan Chand Sarkar's case, Kalyan Chand Sarkar versus CBI. Kalyan Chand Sarkar versus Rajesh Ranjan alias Pappu Yadav. 2004. Justice K. Santosh Hegde delivered the judgment. Pappu Yadav, a politician in Bihar, was accused of being part of a criminal conspiracy that led to the murder of his political rival, the MLA Ajit Sarkar. In Purnia district of Bihar. Ajit Sarkar was assassinated. He was eliminated because of political rivalry. So was the indictment against Pappu Yadav. The CBI investigated this case. Finally, a charge sheet was presented. The investigation took a long duration of time. So while he was in judicial custody, Pappu Yadav applied several times for bail. Read section 439 of the CRPC. I will tell you in detail something about section 439 CRPC as well. Section 439 CRPC. You became aware, you have now a full knowledge of section 436 and for section 437 of the CRPC. Now let us dwell for some time on section 439 CRPC. If the judicial magistrate doesn't give bail according to section 437 of the CRPC, if the judicial magistrate doesn't have the power at all to give bail, read section 437 of the CRPC, then the accused person may land up on section 439 CRPC, which gives a special powers to Sessions Court or High Court in order to grant bail. In order to grant bail. In a murder case, generally or necessarily the bail may be given by the Sessions Court or High Court depending upon where the accused has applied for bail. So, section 39, the power contained therein is not to be exercised by judicial magistrate. This one constitutes the domain of either the Sessions Court or the High Court. Bail application before the judicial magistrate has been rejected by him, then he may apply to the Sessions Court before the additional district and session judge or district and session judge for bail under section 439 of the CRPC. Section 439 CRPC gives a special power here to the Sessions Court. He may release a person, the sessions judge, he may release a person even if the accused person is involved in a murder case where death punishment or life imprisonment is a punishment which may result on the conclusion of the trial. So, Sessions Court rejected his bail application several times. He then applied to the High Court invoking its special power via section 439 of the CRPC, and High Court in its turn also rejected several times his bail application. And as a result thereof, he preferred a special leave petition to the Supreme Court by way of Article 136 of the Constitution, requesting bail from the Supreme Court. And Supreme Court in its turn also rejected the special leave petition for bail several times. This process continued for some time. While the examination of witnesses was still going on, and it was some 3 years now, one day Patna High Court granted him bail. Over that bail order, the brother of Mr. Ajit Sarkar, the deceased person, the name of his brother is Kalyan Chandra Sarkar, he preferred a special leave petition before the Supreme Court according to Article 136 of the Constitution. And thus the case for cancellation of bail came to the Supreme Court. Before the Supreme Court, an argument was laid by the advocate of Mr. Pappu Yadav that on a previous occasion the Supreme Court had said in the same case that bail can only be given by a Sessions Court or a High Court if the conditions provided for in section 437 stand fulfilled. So, while granting or rejecting a bail application, the Sessions Court or High Court will have to cast a look at section 437 of the CRPC, and they may impose conditions, similar conditions, the ones existing in section 437 CRPC while granting bail to a person who has section 439 CRPC. The counsel, the lawyer, the advocate addressing the court on behalf of Pappu Yadav said to the court that section 439 constitutes a different kind of power for the court. It stands on a different footing, very distinguishable from section 437 of the CRPC. Section 439 CRPC is an independent provision. A person may not be suitable or fit, keeping in mind the conditions of section 437 in order for him to be able to released on bail, but still the Sessions Court, exercising his special powers, can grant him to bail. Reading section 437, reading the conditions and stipulations contained in section 437 is not desirable when an application under section 439 is being considered. Both are independent provisions. The Supreme Court in its judgment negatived these arguments and said that section 439 and section 437 are not mutually exclusive. The conditions for grant of bail as laid down in section 437 apply mutatis mutandis, apply with full force to the provision of section 439 as well. If a person is charged with a serious offence, then before giving him bail, the court should consider many times whether he should be given bail or not. So, keeping in mind the seriousness or severity of the crime, keeping in mind the severity of the punishment which the trial may entail, which the trial may result in, whether the person is a flight risk or not, if he has roots in the society or not, whether his presence can be procured either before the police officer or the court if he is released on bail. These considerations will certainly play their greatest role when an application under section 439 is being considered. And the Supreme Court said, the Supreme Court cancelled the bail of Mr. Pappu Yadav and said that he shall not be released, and the High Court, when it passed the order with which he was released from bail, was not a proper exercise on the power on the part of Patna High Court, because a person has remained in custody for several years and trial is still going on. That itself may not become a condition for his grant of bail, for him granting a bail. If the case involves death punishment, then no matter how long a person has been kept in incarceration while being under trial, itself doesn't play any role here, because the punishment itself is death or life imprisonment. So what, the person has undergone 3 years time and the trial is still going on, he should be released. These are not the conditions mentioned in section 437 CRPC, the Supreme Court said. Of course, the accused has a right to renew his bail applications, but every time he will have to convince to the court, every time he will have to convince the court that certain new developments have taken place. Keeping in mind those new conditions, bail has become an appropriate concession on the part of the court. And while rejecting or granting the bail application, the court must pass a speaking order so that the prosecution, the accused, the victim get to know that on what basis bail application has been granted or rejected, whether it has been a reasonable exercise of power or not, whether it has been a judicious exercise of power or not. Another case which I would like to quote is also of very recent origin. Former Finance Minister Mr. P. Chidambaram's case. P. Chidambaram versus CBI, 2019. P. Chidambaram versus CBI. P. Chidambaram, former finance minister, during the Congress government, was taken into custody by the CBI. The case was based on an occurrence or a series of incidents that took place in the year 2007. One INX Media Limited, INX Media Limited of Peter Mukherjee and Indrani Mukherjee fame, applied to the Foreign Investment Promotion Board FIPB for approval of investment, and the FIPB in its term granted approval for investment of 4 crores and 60 lakhs rupees by INX Media Limited into an Indian company. Later on, a consultancy company owned by the son of Mr. P. Chidambaram, the name of the son of Mr. P. Chidambaram is Karti Chidambaram. The consultancy company, it is the allegation, it is the indictment contained in the CBI report, that the consultancy company owned by Karti Chidambaram, the son of Mr. P. Chidambaram, manipulated something. He manipulated the officials of the FIPB. He manipulated also his father as well, and somehow got approved an investment proposal of 305 crores rupees by the INX Media Limited. And for this consultancy, he was paid through check. Mr. Karti Chidambaram received money through check for this consultancy services. Allegations were inquired into. The CBI investigated the matter, and the involvement of Mr. P. Chidambaram into the commission of the crime became apparent. Apprehending arrest, he filed a bail application with a section 438 of the CRPC for anticipatory bail. Section 438 CRPC contains provisions regarding anticipatory bail. If a person is apprehending arrest, he is in fear of getting arrested, then he may apply for bail so that he could not be arrested at all. And even if he is arrested, he could be released on bail from the police station itself. So this is called anticipatory bail. The power of anticipatory bail, the power of granting anticipatory bail via section 438 CRPC is exercised either by the Sessions Court or High Court. Mind you, judicial magistrates cannot make use of this power of anticipatory bail. So Mr. P. Chidambaram, as he apprehended arrest because allegations had become apparent, he applied to the Delhi High Court for bail. And the Delhi High Court in its turn granted him bail on May 21st, 2019. Anticipatory bail, May 31st, 2019. Anticipatory bail was granted to him. But this anticipatory bail order was not full and final. It was only an interim protection that was given to him. That let the prosecution come up with its own explanation, then a final hearing will take place as is the requirement of the law. Till then, you are being given interim protection, you will not be arrested. Even if you are arrested, you shall be released from the police station itself on you executing a personal bond for the purpose. So while investigation was still going on, and when the matter came up for final hearing, the Delhi High Court revoked the interim protection and cancelled his anticipatory bail. Cancelled his anticipatory bail in August 2019. On 20th of August 2019. And the moment his anticipatory bail application was rejected by the Delhi High Court in its final order, the CBI became eligible, capable or well authorized to arrest Mr. P. Chidambaram. Because section 438 CRPC says that if anticipatory bail application is rejected by the court, then the officer in charge or the investigating officer becomes authorized to take the applicant into the custody. So here the apprehension loomed large that any time Mr. P. Chidambaram can be arrested by the CBI on 20th of August 2019, because his bail application, anticipatory bail application, was rejected by the Delhi High Court. So he preferred an appeal, special leave petition to the Supreme Court. Because his anticipatory bail application was rejected by the High Court, Delhi, he preferred an appeal to the Supreme Court, a special leave petition. And while a special leave petition was still pending, on the 21st of August 2019, Mr. P. Chidambaram was arrested by the CBI. So nothing happened in terms of the petition that he had filed before the Supreme Court. He was sent into the custody. Now the regular bail provisions were to apply to his case, because the offences that he was charged with were very serious one: conspiracy, criminal conspiracy, section 420 of the IPC, cheating, section 8 of the Prevention of Corruption Act 1986, section 13 subsection 2 of the Prevention of Corruption Act 1986. These were the serious allegations on the basis of which Mr. P. Chidambaram was arrested. He applied for regular bail according to section 439 of the CRPC, and that bail application, regular bail application, was rejected by the Delhi High Court. When the Delhi High Court rejected his bail application on September 30th, 2019, he went over to the Supreme Court by way of Article 136 of the Constitution. He filed an SLP for grant of bail. The Supreme Court in its turn considered the matter threadbare and insisted on three considerations, because these three considerations had formed part of the bail order, rejection of bail order passed by the Delhi High Court. Whether he is flight risk or not, whether he has a tendency to destroy the evidence or not, whether he has a tendency or whether he has a chance to affect or influence the witnesses or not. Flight risk, tampering with evidence and influencing of witnesses. These three considerations had mattered with the Delhi High Court as it rejected the regular bail application of Mr. P. Chidambaram on September 30th, 2019. Because the CBI had said in its argument that the person, Mr. P. Chidambaram, is a flight risk. He may run away to a foreign country, he may slip out to a foreign country. He may tamper with evidence, documentary evidence, and he is a person of a stature. He has been formerly the finance minister of the country. He has a lot of guts, he has a lot of resources. He can influence the witnesses of the case. He will prevent them from disclosing the material facts before the CBI or before the court. Delhi High Court had said that, look, this person is not a flight risk, and the apprehension or fear of flight risk can well be taken care of if you seize his passport, if you ask him to present himself regularly either before the CBI or before the judicial magistrate. You may issue a lookout notice for him as well in order to know his whereabouts every time. And so far as his chances of tampering with evidence is concerned, the Delhi High Court had said in its order that look, all the documentary pieces of evidence are now well in the possession of the CBI. So therefore, there is no risk at all so far as the disturbing or destroying the evidence, the documentary evidence is concerned. But so far as the third aspect, whether this person has the resources to influence the witnesses of the case, the Delhi High Court said that of course the applicant, this Mr. P. Chidambaram, is a person of a stature, he may very well influence the witnesses of the case. And based on this point alone, the Delhi High Court had rejected his bail application, over which he preferred an appeal to the Supreme Court by way of a special petition under Article 136 of the Indian Constitution. The Supreme Court said in its term that look, the power to grant bail or the power to reject bail are not supposed to be exercised in a mechanical or cavalier manner. It has to be exercised in a judicious manner. Of course, the person may be having the stature to influence the witnesses, but whether he has done so actually, whether he has made any move in this direction at all, whether he has approached any witnesses so as to influence them, so as to deter them from disclosing the facts either to the CBI or to the court. If no such instance has been complained of, then why keep him in incarceration for a longer time? The Supreme Court thus accepted the arguments of the counsel of Mr. P. Chidambaram. On behalf of Mr. P. Chidambaram, it was also argued that if witnesses are vulnerable, they may well be given protection. There is a scheme of witness protection. Witnesses can be protected. They can be immune. They can be immunized from any kind of influencing at the hands of the accused. The Supreme Court in Mahendra Chawla case of 2018 has laid down the law with regard to the protection of witnesses. Why not invoke the law settled in Mahendra Chawla case and provide protection to the witnesses? They will remain unaffected. They may not be influenced by Mr. Chidambaram. So this way, neither flight risk, nor tampering with evidence, nor still influencing of the witnesses played any decisive role, and the Supreme Court chose to grant him bail finally. And this way, the important case law we have discussed by now. By now you have become very clear in your mind that if the criminal case, if the offence is a cognizable case, if it is a non-bailable case, then the police will not have the power to grant bail. According to section 437 of the CRPC, the judicial magistrate will have the power to grant bail here. But in serious offences like murder, where death punishment or life imprisonment is the punishment, judicial magistrate shall not exercise the power to grant bail. Then that power belongs to either to the session court or to the high court according to section 439 of the CRPC. Now something about new developments, and the new development is related to certain amendments made into the CRPC. The Criminal Law Amendment Act of 2009, Criminal Law Amendment Act passed by the Parliament in 2009, which actually came into effect from November 1st, 2010. This amendment is of very great importance, and this takes us to section 441 of the CRPC. section 437, section 41 of the CRPC 1973. Section 41 of the CRPC contains power of the police to arrest. When will the police make an arrest? These rules, these conditions have been provided for in section 41 of the CRPC. If a person has committed cognizable offence in the presence of a police officer, then he shall immediately be taken into custody. This is the rule contained in section 41 of the CRPC. But if the person has committed, or if the person is alleged to have committed a crime which is though a cognizable crime but not punishable with an imprisonment term of more than 7 years. If the crime is one of less than 7 years imprisonment, then it is not necessary for the police officer to make an arrest. The point is, the crime which is alleged to have been committed entails an imprisonment of less than 7 years only, then arrest is not necessary or mandatory, all which. The rule of law that I began my lecture with was that if yours is a cognizable offence and if yours is a non-bailable offence, then you certainly will be arrested, no doubt. But here this law, section 41 CRPC in its new form with effect from November 20, 2010 says that not in all cases, though they are cognizable ones, though they are non-bailable ones, yet if the punishment is of less than 7 years prison term, then the arrest is not necessary. So what the crime is a cognizable one, so what the crime is a non-bailable one. If the crime entails a punishment of less than 7 years, it is not necessary for the police officer to proceed and make an arrest, all which. But yes, if the police officer wants to arrest a person in a crime which is of less than 7 years of imprisonment, he may very well do so. But before that, he will have to satisfy himself. The police officer will have to satisfy himself that whether this person, if not arrested, will cooperate with the process of investigation or not. Whether this person, if not arrested, will commit any further crime or not. Whether this person, if not arrested, will cause or will make inducement, threat or promise to any of the witnesses from preventing them from disclosing the facts relating to the case. So, if the police officer is of the opinion that this person has a tendency to crime repeatedly, this person is a flight risk, he may not cooperate with the process of investigation if kept at large, and this person has the means and resources and the tendency to make inducement or threat or promise to the witnesses in order to influence them, then the police officer, despite the proscription of the section 41, can very well go ahead and arrest that person. Every time the police officer will have to write down in his case diary that this person is a very serious offender, he poses a flight risk, he will not cooperate with the investigation, he may commit further crime, and his presence at the police station or at court in future may not be procured without him taking into custody first. Then only can the police officer proceed and make that arrest, otherwise not. Why this amendment was brought in the year 2009? The reason is section 498A of the IPC 1860. Section 498 has become a kind of household provision. On a notorious note, I say this, that it has become a very household kind of provision, section 498. And section 498 provides for punishment for the offense of cruelty. If a married woman is subjected to cruelty by either her husband or the relatives of her husband, then the husband or his relatives may be punished for a term of imprisonment up to 3 years' time, or with fine, or with both. Section 498, as per the first schedule of the CRPC, section 498A as per the first schedule of the CRPC is a cognizable and non-bailable offence. What used to happen was that a disgruntled wife, a cantankerous wife, usually goes to the police station, lays a complaint there against her husband, that my husband is always torturing me, he is always subjecting me to cruel behavior, and because the offence is a cognizable one, non-bailable one also. So, once the FIR is registered, the police gets the power to arrest the husband immediately. The family members of the husband, his father, his mother, his sister as well, they are taken into custody immediately. And this provision became a very monstrous kind of a source of power for the police. It became a lucrative source of corruption for the police as well. I am not saying this, the Supreme Court has said this. So, a lot of misuse, a great deal of misuse was reported of this provision of law, section 498A, on very flimsy, very minor kind of allegations. Husbands, the father of the husband, the ailing grandmother of the husband, the relatives of the other relatives of the husband were put into prison. So, the Law Commission undertook a research into the matter, and the Law Commission of India, Law Commission, in its 177th report, suggested certain amendments into the CRPC in order to ensure that the provisions of section 498 IPC are not misused at all. Disgruntled wives, grieving wives do not unnecessarily, without reason, put in jeopardy the life and situation of the husband unnecessarily. So, section 41 of the CRPC was amended accordingly by the Criminal Law Amendment Act 2009, and now the section 41 of the CRPC says that if the crime alleged is one involving punishment of less than 7 years, then it is not mandatory for the police officer to arrest the accused, even if the crime alleged is of cognizable and non-bailable type. Then also the police officer does not have the power to arrest if the punishment relating to the crime is of less than 7 years imprisonment. But yes, police officer can very well arrest if the person is suspected or is having the tendency to commit further crime, if the person has the tendency not to cooperate with the police or investigation or the process of court, or if the person has the tendency of making threat, inducement or promise to the witnesses in order to derail the course of investigation or trial, then the police officer may arrest the accused immediately. Otherwise, if the police officer decides not to arrest the accused because the accused is charged with having committed an offence of less than 7 years imprisonment, then the police officer will go a step further and exercise his powers given in section 41 capital A of the CRPC. Mind you, this section 41 capital A was also added into the CRPC. Why? The Criminal Law Amendment Act of 2009, it came into effect from the year 2010. Now, section 41A capital A is about notice. Mr. A, suppose Mr. A is charged with having subjected his wife to cruel behavior. His wife laid a complaint to the police. The police in its turn registers an FIR via section 498A of the IPC. Because section 498A IPC contains a maximum imprisonment term of 3 years in terms of punishment, because it is a cognizable and non-bailable offence. Therefore, Mr. A was taken into custody by the police. It was prior to the year 2010. In the aftermath of 2010, what will happen? Mr. A would not be taken into custody, because the punishment here is of less than 3 years. Therefore, arrest is not necessary. But Mr. A will be given a notice by the investigating officer, and the notice will be based on the section 41 capital A of the CRPC. This notice will take an undertaking from Mr. A that you will keep cooperating with the police in course of investigation. You will keep attending the court and as and when required by the court. And on this condition, the police officer will not arrest you at all. But if you were to commit any crime further, then maybe this notice via section 41 IPC will via section 41 capital A CRPC will have no effect. You may be arrested. And a recent case law, a very famous case law in this behalf is well in point, and the case law is Kumar versus State of Bihar, 2014, Supreme Court. The husband Kumar was arrested. His wife had made a complaint against him. Section 498A. In the process, finally the case landed up at the Supreme Court, and Supreme Court said that because section 498A is a cognizable and non-bailable offence, the fact that section 498 is a cognizable and non-bailable offence has lent it a place of pride amongst the provisions that are used as weapon rather than shield by the disgruntled wives. They are oftentimes misused. So, why not give the benefit of section 41 CRPC to the accused? The imprisonment is up to 3 years here. Section 41 says that if imprisonment term is less than 7 years, then the person shall not be arrested. He will be given a notice with a section 41A CRPC, and according to the terms of the notice, the accused shall promise or undertake to the police officer that I shall keep attending the police station in order to assist in the process of investigation, or I will keep attending to the court in order to assist in the process of trial, and if I commit any further wrong, I may be taken into custody. So, why not this benefit of law is being given to such kind of destitute people? Why these kind of mischiefs are being allowed to continue in perpetuity? Husbands are unnecessarily, their relatives are unnecessarily taken into custody. Their ailing grandfather, grandmothers are also taken into custody. This is a very bad scenario to behold. Let us do something. Let us enforce in letter and spirit the provision of section 41 of the CRPC. Let us give the benefits of section 41 capital A to the accused. Do not arrest him if arrest is not absolutely necessary. Right? And the same proposition of law was repeated in a very recent case of Satyendra Kumar Antil versus CBI 2022. Here also the Supreme Court quoted with approval the law laid down in Arnesh Kumar judgment that if crime alleged is of less than 7 years imprisonment, the accused shall not necessarily be arrested. Arrest may happen only when the accused poses a serious risk of committing further crime, he poses a serious risk of not cooperating with the investigation or trial, he poses a serious risk of influencing the witnesses, then only can he be denied the benefit of section 41. Otherwise, in all cases where the punishment is of less than 7 years imprisonment, though the case is a cognizable and non-bailable one, the accused shall not be arrested. And if he is arrested, then according to section 57 of the CRPC and article 22 of the Indian Constitution, when he will be produced before the judicial magistrate, the judicial magistrate will have to make an inquiry, a judicial inquiry, that whether the investigating officer applied his mind to the case, whether the case is one involving less than 7 years imprisonment, then why the police officer, the investigating officer didn't choose to give him the benefit of section 41A, why this error was committed by the police officer. If the investigating officer IO remains successful in satisfying the court that this person is a very serious criminal, is a very notorious criminal, that's why I arrested him, otherwise he would have fled from the course of justice, then only will the judicial magistrate will approve such a course of action on the part of the police. Otherwise, the judicial magistrate will disapprove of the exercise of power of arrest on the part of the police officer if the person has been arrested in such a case. Though the section 41 applies, said section 41 of CRPC applies, yet he was not given the benefit of it. Why? Judicial magistrate will always ask. And non-granting of bail, non-granting of the benefit of section 41 capital A CRPC will always inure to the benefit of the accused. He will be released anytime on bail. So, this is how the whole process of bail jurisprudence, the whole aspects of bail jurisprudence has evolved in our country. In Satyendra Kumar Antil case itself, the Supreme Court suggested to the government that why not enact a separate bail law as is there in England, so that the provisions of bail are not misused either by the police or by the court. The benefit of bail is granted in a more judicious manner, with there being the very least chance of personal discretion being exercised either by the police officer or the court. So, by way of summary, we can say chapter 33 CRPC from section 436 till section 450 contains the provision of bail. Bail has not been defined in any legislation. Bail is a conditional release either given by the police officer or by the court. Section 436 provides for bail by the police officer, means release from the police station itself, is given in section 436 of the CRPC. When the offence alleged is a cognizable and non-bailable type, then the accused who has been arrested and detained in custody shall be produced before the judicial magistrate, and judicial magistrate exercising his powers with section 437 CRPC may grant him bail, regular bail, with the condition that you will not be committing any further crime, you will be always cooperating with the course of investigation and trial, and you shall honor the terms and conditions of the bail order, and you shall not be influencing or making any inducement, threat or promise to any witnesses so as to prevent or dissuade them from disclosing any facts either to the police or to the court. And in serious offences, if the person has been arrested and detained in custody, then the judicial magistrate is not required to exercise his power of granting bail. That power of grant of bail shall be exercised by the Sessions Court or High Court. In fact, section 439 of the CRPC provides for a special power of Session Court or High Court. And if a person is apprehending arrest, he has not been arrested yet, but there are situations, there are facts and circumstances which give rise to a suspicion or apprehension in his mind, like Mr. P. Chidambaram in the case that we just discussed. So, he may be in fear of getting arrested, so he may apply for anticipatory bail. Anticipatory bail. Bail in anticipation of an arrest. If a person is conceded to, if a person is given anticipatory bail, then at the time of his arrest, he shall be released if he executes a bail bond for the purpose, that is called anticipatory bail. And the conditions of bail are in so many terms given in section 437 CRPC. Thanks to the several judgments of the Supreme Court, it is now well settled that the conditions set out in section 437 CRPC apply in full force to the provisions of section 439 and section 438 CRPC as well. Regarding the overall situation and scenario concerning bail, the recent development has happened in terms of the amendment into the criminal law in 2009, which modified section 41 of the CRPC and said that if the crime is one involving less than 7 years imprisonment, then arrest may not be necessary. Rather, a notice with the sections 41 CRPC shall be given to the accused, and he shall be allowed to remain free if he cooperates with the investigation. Section 41 CRPC in its amended form says that if the person is having the tendency to commit crime, if he has the tendency to influence the witnesses, then the benefit of section 41A might not be given to him. The Arnesh Kumar judgment of 2014 is of very long term implication. It says that the benefit of section 41A must be given to the accused of section 498 IPC, and not only section 498 IPC, but other offences as well, where the punishment is of less than 7 years imprisonment. So, this sums up the whole conspectus of bail law in our country. I hope you stand enlightened as a result of this lecture. I will be giving some more detail as regards the case law in further classes as well. Thanks for watching. Thank you.